Hi friends from around the world. This is today about champagne. So keep with me, that seems interesting. What we have is a Veuve Clicquot case, and it went to the General Court. It is a quite complicated case, but bear with me. Once we get to the conclusion at the end of the video, the morale is quite clear, and we can draw good conclusions for the lawyers, how to react and how to advise their clients, which is all about in this channel, right? So let's see. There are in fact two subsequent proceedings I want to go through with you. It all starts in 1998, so quite some time ago, 22 years, right? And it involves the trademark application orange color, so to say. It appears here on the screen. That is what it is. It is on every bottle of Veuve Clicquot champagne, you know this, and it was applied for goods in class 33 champagne wines. So far, so good. Well, in the examination process, the examiners determined that this has to be rejected, lack of distinctiveness. So that color we have here, we have seen lack of distinctiveness. Now it said also the examiner in its dismissal of the filing, it said that if a color mark has been applied for, then the corresponding box should be ticked, because the box which has been ticked by Veuve Clicquot was a figurative mark. So there where it all starts, the headache starts here. Now, Veuve Clicquot applied to the Boards of Appeal in an appeal against the dismissal of its application, and the Board of Appeal, it was in that case the second Board of Appeal, it said, well, in reality what Veuve Clicquot wanted is a color mark. They don't want a figurative mark, although they have ticked the box figurative mark. But what is all clear here from all the circumstances is that this is a color mark. So it cancelled, it annulled the decision of the examiner and remitted back in order to have a fresh look at it with a clear vision that this is a color mark. So the examiner again dismissed the appeal, the filing, the file, so the application, and it went again to the second Board of Appeal. Now, what does the second Board of Appeal now looked at? They annulled again the cancellation division decision by admitting the filing under the heading of, so to say, acquired distinctiveness. So evidence of use was presented and that conducted the Boards of Appeal to admit the trademark as registrable. And then it went into the register in 2010 or so. It went into the register, and it was what then afterwards has been determined by EUIPO staff as an error. It was registered as figurative mark. So that is already 10 years in the proceedings, and what they got is just a trademark. So, you know, 10 years, 2 times to go to the Boards of Appeal, and the lawyer fees, well, it was quite substantial already. Now we come to the second part of the proceedings, not the second proceeding, so to say. And this starts in 2015. with Lidl, the discount retailer, which filed an invalidation application against the registration of Veuve Clicquot by saying, well, this color has not been clearly determined because it was a scientific explanation given by Veuve Clicquot, so this is not clearly, and this is not qualifying as a trademark, and in any case lack distinctive character as such. Now, the cancellation division dismissed the invalidity application in 2018 by saying, well, this is a color mark. It has been identified clearly by the description of what it is. It's intensive orange. It's a scientific description which has been applied, and in any case, it has acquired distinctiveness through use, which has been confirmed by the Second Board of Appeal previously. So from the cancellation division, the Lidl appealed to the Boards of Appeal and went now to the first Boards of Appeal, to the first Board of Appeal, so a different Boards of Appeal, meaning that at the EUIPO we have in total 5 Boards of Appeals at a certain moment, and they have a key of distribution and one and the other, and well, it went in this case to the first Board of Appeal, which is different from the others and has different personnel, different members of that Board of Appeal. So they get to make, so to say, a fresh look on the issue. Now, the first Board of Appeal said that the second Board of Appeal at the time, right? So that was 10 years before. They erred, they did wrong to qualify the trademark application as being filed for a color mark. It should have been filed for and assessed to be filed for a figurative mark. It's not only that the corresponding box has been ticked by Veuve Clicquot by the time, so 10 years ago again. No, it is also that Veuve Clicquot in its filings and the parties in its filings and briefs, they have also referred often to a figurative mark. So the Second Board of Appeal in the ruling some years ago, they were wrong. So they sent it back. They annulled the cancellation division decision. They sent back to the cancellation division in order to give a new look at it in the light of a figurative mark, right? So the cancellation division had it back, but in the meantime, the Veuve Clicquot, they appealed to the General Court. So it was a annulment of the decision of the cancellation division, which grieved in a certain moment, at a certain instance, to a certain extent, the position of Veuve Clicquot, and they were able to go to the General Court against that remittance, annulment of the cancellation decision and the remittance to the General Court. So the General Court declared the appeal as admissible. And what was now the position of the General Court? Well, they said that they didn't go into the old issues of the Second Board of Appeal. They could not, because this is beyond scope, so to say. They had only a ruling on the decision, which is the decision of the First Board of Appeal, which is part of that gist on which the General Court has the only ruling to base upon. Now, what they said is in line with what Veuve Clicquot argued, is that according to Article 96 of the Statute of the Court, it is clear that to the European the trademark regulation, according to European trademark regulation, the board can only base its decision on what has been presented by the parties. They cannot extra limit in inter partes cases. They cannot introduce on its own motion new facts, new evidence, new arguments, new whatever it is into the mix. They are limited in inter partes proceedings by the arguments raised by the claimant, by the appeal, by the brief of the appeal, and if there's a counter appeal, they are limited to what are the arguments and evidence presented in the counter appeal. Now, what you cannot do is in inter partes proceedings, so where third parties are involved, relative grounds, right here, invalidity, we have third party, we have one party against the other party. In absolute grounds, we would have ex parte only. There's one part, so that's different. But here in inter partes proceedings, the Boards of Appeal is limited to the reasons and evidence presented by the parties. None of the parties, had raised the issue of the type of mark which has been filed by the Veuve Clicquot. So in its own motion, it was an extra territory where it shouldn't have been. So that is wrong. That is the first issue. The second issue, the right to be heard. So if you want to put something in the reasons where you base your decision on, you have to hear the parties before in order to gather their arguments and then base on something where the parties have been heard for. So at the end, it was annulled. It was referred back to the Boards of Appeal. And, I do not went further whether the Boards of Appeal, they meant a decision or they referred back to the cancellation division in order to, start all over again. But what we see here, we have about 20 years. Well, there was the 5 years where nothing happened between 2010 and 2015, but still, we are still here in the process of one registration from Veuve Clicquot. So we are 10 years of litigating here and 20 years in time since the filing. So that is heavy and this is burdensome, and this is together linked with high cost. You have to know that the losing party in the proceedings in front of the EUIPO and in front of the court, the general court, the losing party normally has to pay the winning party the litigation cost, so the lawyer's cost, the lawyer's fee, so to say. But this is in EUIPO only 350 or 450 euros, depending on the proceedings. So it doesn't cover by large what is the actual cost incurred by the parties. And in the general court proceedings, much more the same. You get more reimbursed by the general court, yes, but the real cost of the lawyers, they are much higher. So in any case, the parties are still with some cost, and it may be heavy because each party may have incurred cost of 20,000 euros probably on litigation costs in front of the European General Court. So this is one thing to the time and the cost due to an overlook in the beginning, and that is my second remark here. It is very important to have a look in the beginning and to make clear what is being applied for, because everything started in the beginning where we have a color mark, which is just a square with a color, and we have ticked the box figurative mark. So you have to be very aware and look at the small things which may become big things afterwards and big headaches afterwards, so to say, if they were wrongly focused from the beginning. Now, a third thing here I want to mention is the difference between a color mark and a figurative mark. What we have normally is word marks and figurative marks, which makes up 90% of the trademark applications what we have now. But there are other marks like pattern marks, like position marks, or like sound marks, or, well, non-traditional marks. And we have the color marks. Now, for there are consequences if it is one mark or the other mark. In that case, we have here a acquired distinctiveness, and acquired distinctiveness with regard to the figurative mark. Well, that is the exact use of the figurative mark, of the shape which has been presented to EUIPO. Whereas, if it is a color mark, we don't need to present that shape, that exact square, to the products. It is only the color, right? So there are consequences for the evidence which has to be presented for the acquired distinctiveness. So it is not just a tick box and a tick box and that's it. So it is not consequential. It is consequential if you have a link before, and lawyers are there in order to know that. Thanks for tuning in and giving me a like.